Okay, this is part two. I apologize. The last video I ran out of memory on my phone. I was given some information by a great channel for child support information. If you want to really know how to fight these people, it's Amen Osiris. AMEN OSIRIS. I think I've said in other videos, in my comments, I had a good idea what I was doing, but when I found his site, he put everything in motion. Like, I couldn't understand how a fake judge can make a court order, and then I realized that it wasn't a court order; it was an administrative order, and it was an administrative hearing. See, what they do is they carefully disguise these administrative hearings inside the court. So when you're in family court, when you're inside the hearing room, you're technically not part of the court. You're part of an administrative hearing, which is conducted by a surrogate judge. And New York State, under New York State trial rules, it's a support magistrate 205.32, which says she's an appointed, or he's an appointed non-judicial officer. So in my case, I have a judgment for divorce, which you see right here. I have a stipulation of settlement, which you see right here, which is dated September 14, 2004. That's the agreement. This is March 1st, 2005. And this is I was telling you, the fake court order. Here's the fake court order made by Sudeep Kaur. See how it looks like a court order? And this... she claims I had to pay $11.31 biweekly to support collection unit. She claimed that I owe $40,723.38 by retroactively increasing my support. Not because I didn't pay support, because she retroactively increased, which she cannot do. So this woman's like really out of her territory, like way out of any realm of power that she has, and she has none. No power at all. She's a zero. And she plays the role. They call her Your Honor and judge inside the hearings, and it's all for show. Everybody's in on it. The judge, the court officers. I don't know if they're in on it because they're pretty dopey people. They're pretty dumb. The court officers, I found. So I think they really believe they are judges, but the lawyers are in on it. So as it says here, support. This is a continuation. It is ordered that Richard Warman Jr.'s retroactive support. Now she's being clever where it's retroactive, but it really is a retroactive increase, dating from September 17, 2014, dating back to April 1st, 2007. Now this alleged petition to family court, was started on September 15, 2010. When my lying ex-wife went to court and lied about everything, and she alleged that I wasn't paying support and all this other nonsense, but she couldn't prove any of it. But I had to go to court, and it was up to me to prove everything. I did, and everything was ignored. So anyway, and this was dated September. Well, this is the July 24th, but they didn't send it to me till September 24th. And they're referencing the divorce here, but meanwhile, family court has no jurisdiction with anything incidental to divorce hearings. Okay, so it's all everything's a fraud just to get your money. Okay, and see how she signed. It's here. She makes it look like it's signed by support magistrate. Enter. There's no stamp from the court. It's not entered by a clerk. So it's all fraud. Okay. So anyway, getting back to so she creates this fake court order, creates an income withholding order. I showed you in the last video, but here's something interesting. This information is from the Office of Temporary and Disability Assistance. They're in charge of child support in the state of New York. Okay, now. Remember, I was telling you in one of my videos, I went and, I look at their rules. These are rules that they're supposed to go by. So when you throw these rules in their face, they ignore them. Now, in my matter, as it says here, modification of orders. If the order was effective on or after October 13, 2010. Now, I showed you here in my stipulation settlement, it's dated September 14, 2004. So we already know that has nothing to do with me. And so what happens, the rules apply to me. If it does apply to me, it applies before October 13, 2010. Now, what happened on October 13, 2010 was New York State increased the child support of combined parents to be $130,000. So if there was two parents and if the father was making $130,000, he could be liable to pay child support of 25% of $130,000. But I'm before October 13, 2010, so I'm only, obligated by my agreement, not because the state told me I had to do it, because I had made an agreement. I'm paying 25% of $80,000, okay, which could be seen in my order here. Husband and wife agree, based on the stipulation settlement, that I'm going to pay $697 bi-weekly for the support of 2 children, based upon $80,262. Okay, and $80,000 was the maximum amount for before October 13th. So, also in the stipulations, husband and wife acknowledge that the amount is set forth within is in compliance with Child Support Standards Act. In compliance, which doesn't mean we are, because this agreement was made to favor my ex-wife. It definitely wasn't made to help me out. They weren't doing me any favors, because they knew that she's on the books for making $10,000 when this happened. So they knew that if she went out and made more money, she would be liable to pay more support. But they never go after the women. Section I here, it says husband and wife agree, hereby waive their right to have child support payable by income execution order through support collections unit. That means that no court can order me to pay child support through support collections unit. And then they throw in, this is the best, at this time. Those 3 little words give people that they can interpret, meaning that she only waived it at that time. No, she waived it, but those 3 little words are thrown in there by some lawyer so they can go to court and argue this stuff. Okay, so now we go to Section K. Notwithstanding the foregoing, the parties intend and agree that the child support obligations of the parties be governed by this agreement and not directed by a court or judge pursuant to the said Child Support Standards Act. This agreement is fixed in a fair and reasonable amount based upon many considerations. So in other words, everything is based on this agreement. Nobody can interfere. This is a qualified domestic relations order. And to make it further, even cement it even further, we go to page 19, where there's a modification and waiver section, where it states that neither this agreement nor any provisions thereof shall be amended or modified except by an agreement in writing, not by some fake support magistrate who if you ever seen this woman or been in a room where you see she's a tyrant, she acts like she can't be questioned. She actually told me that I can't pose questions to her. She's a piece of work. Any waiver by either party of any provision of this agreement or any right or option herein shall not be deemed a continuing waiver. So in other words, she can't change her mind in the middle like she did. She changed her mind on June 7, 2012 and said, you know what? Remember when I agreed that I waive support, to be paid through SCU? I was only joking. I want it now. And that's what they did to me. Now I have a judgment of divorce here. My pension system is ignoring what I just showed you here. All of this here covers me. It says that no court order from family court can interfere. Now page 3, from the judgment of divorce. Ordered and adjudged that the plaintiff's Richard one shall pay directly to the defendant, my ex-wife, the sum of $697 bi-weekly, and for the support of the children. So that's it. And it says, as set forth in stipulation of settlement of parties dated September 14th, 2004. That's it. This is a court order right here, or a judgment. This is an agreement. Now, let me get back to the OTDA here, which says when they can modify an order. Now, it cannot be, now, anything before